Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3226, United States of America versus Anthony Glover, appellant. Ms. Hall for the appellant, Mr. Cahill for the appellate.
Morning, Ms. Bhatti. You may
Good morning.
proceed when ready.
May it please the court, Ms. Rabati, on behalf of Anthony Glover, I'd like to reserve 2 minutes for rebuttal. Mr. Glover asked this court to reverse the district court's denial of his motion to suppress because Ms. Brewer never provided unequivocal, specific, and voluntary consent to allow law enforcement to enter and search her home, and the district court misapplied existing law in concluding otherwise.
Do you consider
Specifically-
the consent that you're discussing to be separated out by consent to enter and then consent to search?
Your Honor, there was a decision made by, yes, there were two points at which the government alleges that there was consent, or that we also contend that there was consent, purported consent. That was at entry, and that was also later to search the home.
But you're alleging a violation as to both. You don't
As
think
to
that
both,
either one-
correct.
Okay.
Yes, and specifically, the district court misconstrued in terms of the legal errors in this case. Foremost among them, the district court misconstrued the consent standard articulated in Bumper and reiterated in Schneckloth, that when a law enforcement officer announces that he has a warrant to search an occupant's home, the occupant has, in effect, no right to resist the search. That's a direct quote from the case, and quote, there cannot be consent. And that is exactly what happened here.
But does it cut against your argument if we read the district judge to have found that he did not assert that he had a warrant to search the home, but that he had arrest warrants?
No, first of all, the district court made two errors there. One is that the district court did not properly read Bumper when it said that there was a critical fact there that distinguished that case, and specifically that police sought consent in Bumper by alluding to a warrant that did not exist, and that is simply not true. The court in Bumper articulated very specifically in footnote, I believe, 15, that there was in fact a warrant.
But doesn't that not
and so
matter?
that's-
Isn't the point not whether there was a warrant or not, but that there was a claim of lawful authority in both cases?
Exactly. But I'm just clarifying that because the district court used that quote critical fact to bring this case outside of the purview of Bumper. But secondly, as Your Honor mentioned, it thought that the fact that Officer Creamer was discussing arrest warrants somehow also distinguished this case from Bumper, and that is also not true.
And there wasn't a distinction on,
I'm sorry?
there wasn't a specific naming distinction, arrest versus search warrant.
No, I mean, Officer Creamer said, I got warrants. That's all he said.
Right.
But the district court said that somehow because Ms. Brewer stated, my brothers are not here, she understood Officer Creamer's statement as meaning arrest warrants, and somehow that was different. But that does not matter. Even assuming that somehow she did understand the warrants to mean an arrest warrant, which is what the district court said, that it wouldn't have mattered. Bumper is about an assertion of lawful authority. And what Officer Creamer did by saying, I got warrants and PG County has your brothers as living here, is he asserted that he had the lawful right to enter her home regardless of whether or not she had consent. And
one
that
thing
is why
I would like to think about is this whole notion of consent. First, I want to back you up into, you said you're challenging consent to enter, and you're also challenging consent to essentially search, which is going down the hallway into the apartment. There seems to be a distinction in case law about consent to enter versus search. You didn't challenge consent to enter specifically.
we did challenge both. we challenged both consent to enter as well as consent to search.
But did you
for
do it in a
purposes-
generic way of consent versus distinguishing those two actions?
I think, Your Honor, we did distinguish those two actions. I mean, Joint Appendix 117 to 118, Defense Counsel noted that Creamer needed her to allow him into the apartment. And also on Joint Appendix 139, she articulated that there are 2 points. It's the entrance and it's also the search for
Okay.
the individual. And later the district court agreed that there were, quote, 2 things
Okay.
being
And
being
where do you
contended.
think the record reflects what she's consenting to? Because that's where I want to spend a little time with you, because to me, consent would then be thinking about a meeting of the minds. Like, do I just open up and say, come on in, and then you're in, do whatever you want?
Right.
Or
And-
is there a consent to something? Because he says, number one, may I come in?
Mhm.
But then it's followed by we
7.
or they. May I go down the hall? But then it's followed by we or they.
Well, Your Honor, we contend that there was no consent at any point,
Okay.
and Your Honor is
But she
absolutely
does say
correct.
come in, so I just want to know where would you say,
Well-
if at all, she's allowing them to do anything? What is she agreeing to?
Your Honor, she never says come in, and that's a key point. She never
'Cause
says
she does at
come
some
in.
point wave them in down the hall.
She doesn't even wave them down. We could, yeah, let me
They
go
got in her
through.
apartment how? What would you
Yes,
say?
Your
How?
Honor is kind of hitting the nail on the head. There's a number of factors here, and they all point in one direction. Now, even if I just want to make sure that I hit that Bumper point before moving off of it. I think Bumper settles this case. Once Officer Creamer said that PG County had the brothers living there, he asserted that he, had the lawful authority to be there, and that is this case. So we can end with Bumper. But if we're putting aside Bumper for a second and we're looking at her actions and the totality of the circumstances, we start, as the district court did not do, with the moment those officers arrived and started knocking at her door. The district court made no findings whatsoever before the Officer Creamer's ask and Miss Brewer's, slight opening of the door, that quiet looking down and opening of the door. The district court did not even talk about the time of day, the number of officers, the length of time that they were knocking, touched on none of that. But if we look at that, at 6:30 in the morning, we have 7 armed officers that start rapping at the door for 2 minutes, right? And then Miss Brewer opens the door immediately. We have open eyes. You saw it on the body worn camera footage. There's no dispute about this. There's her roused from sleep. They're all armed. Some of them have gas masks on, and she looks quite surprised. And then she starts saying one-word responses like, and things like that. And then we have, of course, the pleasantry. Good morning, Miss Brewer, which, obviously the district court focused on. And then we have the badgering. And the badgering is particularly key. We have Officer Creamer stating, I need to talk to you. It's important. And he states that 3 times. And he states, I need to talk to you. It's about your brothers. It's important. And she states why. He says it's about Dawn. She states what? And DeAndre, she states why. He says, I need to talk to you about them. She says something unclear, and he again says, it's important, I need to talk to you. He refuses.
The standard of review on reviewing the totality of the circumstances
Right.
is clear error. So maybe what are the main points where you would say there was a clear error?
I would say,
Because there's, I understand you're making arguments that there were legal errors, maybe under Bumper, but if we don't find that there's a legal error, how do you overcome the clear error standard of
yes, and that, and just to kind of answer both of the questions that Judge Childs also asked, this passage right here, where he is refusing to answer her repeated requests for more information and hiding his purpose, not revealing why they're actually there when she's asking him 3 times. That badgering is something that district court did not look to. It's unreasonable and clear error for the district court to not consider that badgering. That's one of those.
Separating out the entry into the apartment. All this evidence and discussion you're talking about is about the entry into the apartment?
It's about the entry, but it's also about, again, the entire consent question is a totality of the circumstances question. So even if we're looking just at, did she consent within the apartment? Those preceding interactions that happened at the door are part of the totality of the circumstances. That's what Schneckloth said. And that's what a number of courts have held. Griffin is a great example, for example, that you have to look at all of the circumstances from the get-go that create an atmosphere of coercion, that back her, in this case, that literally and figuratively and physically backed her into and against a wall and essentially intimidated her into acquiescence. What she did was acquiescence. It was not consent. And I just want to get back to that badgering. Griffin, which is a case that we cite in our brief, cited Johnson, which is a Supreme Court case just prior to Bumper. And it said that when the deception and trickery on the part of officers who do not disclose the information that they have and wait until they enter the apartment to reveal their true purpose is what Johnson dealt with. And that right there is trickery and part of that whole totality of the
Ms. Bhatti,
circumstances.
I mean, I watched the
Yes.
body cam Warren footage, and I think to describe what Officer Creamer did as trickery or badgering I think that's a pretty tough thing to say, having watched the video. I'm not sure about where the badgering was. I mean, there was polite interchange. I mean, I understand you have a question about consent, but to describe what the officer did here as badgering seems like quite an overstatement.
Well, Your Honor, he stated, I need to talk to you, it's important. And she stated, why? And he refused to answer her question. He again stated, I need to talk to you, it's important. And she stated, why? Or what? He again said, I need to talk to you. That repeated refusal to answer her question, if we don't call it badgering, we could call it insistence or persistence, but the courts have called it badgering, the courts have called it coercion, the courts have called it persistence. And again, I'm just going to point to Griffin, where the court specifically looked at that fact and said that the officers in Griffin disclosed all of the information at the door. They said, we want to talk to you because of this. We want to talk to you because we need to come into your house and look for X, Y, and Z. That did not happen here. They simply essentially flashed a badge. That's what happened in Johnson. And Johnson, that Supreme Court case, said entry into the defendant's living quarters, which was the beginning of a search, was demanded under color of authority. It was granted in submission rather than any understanding of the waiver of the intentional waiver of a constitutional right. It was simply granted because the officer said, we are police officers and we need to come in and talk to you.
So
That
is
was
your
exactly
answer to-
Johnson.
Is that your answer to my question with respect to how do they get in?
Yes, yes.
Because they're flashing
There's,
alleged warrants that she never sees, right?
well, how they got in was they said, we're police officers.
Right.
There's 7 of us. We're blocking your door. We need to talk to you. It's about your brothers. We're refusing to answer any of your questions. You need to let us in. It's important.
And they say they have warrants.
And then they say, can we come in? She opens the door slightly, and that's what brings this case into parallel with, Lindsay, for example, where you have that silent opening of the door in acquiescence. And again, Johnson says the exact same thing. In Johnson, the law enforcement officers testified, I want to talk to you a little bit. and said she stepped back acquiescently and admitted us. Exactly what happened here. She stepped back acquiescently after they said, I want to talk to you, and admitted us. And that is not consent. That is acquiescence to a show of lawful authority based on the totality of the circumstances at entry. Then, after that, so we can test that that is not, we say that that's acquiescence, that's not consent at entry for all of the reasons that I just stated. Then, once they've
Because your
entered,
point under acquiescence would be, who wouldn't allow the officers to come forward if
Well-
you've got warrant, you've got 7 of them there around you?
I mean, yes, and it's a subjective standard. And she, looking at her demeanor, I mean, we have the body cam footage, as the district court said, we don't have to even look at the words of the officers. We have the video in front of us. Her face drops when the officer says, it's about your brothers. I mean, she probably thinks they're dead. He says, it's important. I need to talk to you. Why? It's important. I need to talk to you. Why? It's important. I need to talk to you. Why? He refuses to answer her. What is she, at that point, it's either close the door, don't hear what happens to your brothers that 7 officers woke you up to talk about, or let them in. And she quietly, without any facial expression, mute, looking at the floor, opens the door. It's absolutely clear error to think that that is consent, is voluntary and unequivocal. And let me just make that point too. Unequivocal and specific consent. Is that voluntary and unequivocal, which the district court also did not make a finding.
But it also wasn't preserved. There's a real question about the objection on entry as opposed to your objection on Mr. Glover's behalf to the walking through the.
I mean,
As I read the supplemental briefing, it focuses specifically on, in the district court, it focuses specifically on the walking through the apartment, not on the entry.
well, Judge, I would disagree with that. The two passages that we pointed out were just 2 examples. You know, when she said defense counsel on, again, JA 117, JA 139 specifically says 2 points. There are 2 points. It's the entrance and it's also the search. And then the district court also talked about 2 things. I mean, obviously the district court was focused on the warrants and from the get-go, but the fact that the district court, guided the questioning to a certain point and wanted to focus on the whales and the outstanding warrants does not mean that we intentionally waived the argument as to entry. I mean, it's clearly something we raised from the get-go. And then we cited cases in our supplemental briefing that talk about entry specifically. And we talk about that in our brief. So to think that we intentionally waived it is just not reflected in the record. And then furthermore, the district court, obviously, I think what happened in that hearing is that the district court was very much concerned with the question of, if she opened the door, does that mean she also consented later to the search through the home? And she kept going back to that question because she was very much just trying to figure out, well, if you let him in, does that mean they get to search?
Another thing is I want to, focus on your last word, search, because I want to know how we're defining search. It appears that in the order, I believe, JA 175, that he was explicit, that he just wanted to check each room to ensure that the wanted individuals were not present and that he had no intention of going through drawers or opening containers. So what are you thinking about as search? Because apparently he says, I just want to look for them to see if they're not here. And when you go down in an apartment, I mean, it's very clear, the rooms, you look, they're not there. But then, of course, in plain view, they find the gun. So I'm trying to focus on what are we meaning by search anyway?
Well, what he says is
Was it a search or was it I want to look?
Well, what he says is, what I need to do is I need to visually see that they're not here, check them off, I'm gone. So he's saying, I need to look, and to me, when he says that, he says, I'm not leaving until you let me look and make sure that your brothers are not here, even though you've told
But,
me
but I'm trying to gather the
Yes.
word look. What does that mean?
to search. Yes, I mean, to search.
Look. Like, does
to
that mean
look.
just look? And if they're there or
Yes.
not, then I'm out of here? Or does
That-
that mean look into the contents and everything of the?
Well, he says, and we don't, he says without touching any of your stuff, without disrupting your house. He's saying, I want to look at your
So it's a visual.
brothers.
It's just a visual look.
It's a visual look for the
bodies,
brothers,
for those
for
bodies.
those brothers.
Specifically just that.
Specifically just that. Yeah, that's
So I
what
guess
we don't,
just to kind of clarify on this exchange, if the person doesn't live in the house, then an arrest warrant doesn't authorize police, even if they have reasonable suspicion that the person named in the warrant might be there, an arrest warrant doesn't authorize the kind of entry that occurred in this case?
I mean, that's correct, unless there's a reason to believe that those individuals are in that apartment, right? If, like, we're at a third party's, we're at Miss Brewer's apartment, an arrest warrant wouldn't give him, I mean, that's why the government's relying on consent here. I mean, if they had a valid arrest warrant for this property, they wouldn't need consent in the first place, but he needs consent. And he testified to that. Everyone agrees he needs consent. That's why he's trying to get consent out of Miss Brewer. But the way that he describes, the way that he states, PG County has your brothers as living here, that is key. And I've got warrants. I need to look. Once PG County has your brothers as living here, that's a valid arrest warrant. I mean, that clearly conveys that I have the lawful authority to be here and look for your brothers. PG County has your brothers as living here. I got warrants, shuffling papers. That's an arrest warrant to say I have authority. That is lawful authority to be there.
So what's your request? Because you're arguing no voluntary consent to enter, which, we'll discuss whether or not that was preserved. No voluntary consent to go down the hall and search.
Yes.
And then also this distinction between voluntariness of consent versus mere acquiescence, which that category seems more like a legal error that if you're going that route, that the district court did not make those distinctions.
Yes. I mean, we're contesting the consent at both places, as you know. We're contesting the legal conclusions that the specific actions of Officer Creamer and Miss Brewer were sufficient to constitute unequivocal, specific, and voluntary consent under Lindsay. And that conclusion was not something that the district court made. She never said this is unequivocal and specific, right? So that again, legal error, number 3 right there. The district court did not properly apply bumper. We talked about that critical fact piece of it. And how the district court somehow thought, there's no valid warrant in bumper. So, which is wrong, which is just flat wrong. That's not the case in bumper. And then it also thought that the understanding of arrest warrants somehow distinguished, this case, which is again wrong because the way that Officer Creamer stated, PG County has your brothers living here and I got warrants. He absolutely conveyed that I have the lawful authority to be here. And Miss Brewer, now, that means that I have the lawful authority to be here. And actually, I wanna just highlight, because I think it's a useful just something to point out, is Justice Harlan's concurrence on page 552 of bumper. He states that with respect to Miss Leith and in bumper, nothing Miss Leith said in response to the announcement of the warrant can be taken to mean that she considered the officers welcome in her home with or without a warrant. What she would have done had the sheriff not said he had a warrant is on this record a hypothetical question about an imaginary situation that Miss Leith never faced. Same thing here. It's pointless to think about well, what if the warrant statement didn't exist? Or what if there, what if this wasn't an arrest warrant? Or what if it was actually, the arrest warrant wasn't actually valid, or we thought that, it didn't mean it was, it doesn't matter. She heard the word warrants. He said, I got warrants. We don't need to go meandering into an imaginary situation. Once he said that, then that's it. Okay. I'll reserve the rest of my time for rebuttal. Thank you.
Morning, Mr. Cahill.
Morning, Your Honor. May it please the court, Timothy Cahill for the United States. The district court in this case carefully reviewed and considered the evidence, made the permissible finding that Ms. Brewer understood Officer Creamer's words to her to be a request to look through her apartment, and that she voluntarily consented to that request.
Look through her apartment or look for somebody?
Well, to look through her apartment to look for her brothers, to be more specific, Your Honor,
But when you
yes.
say through, it still seems that you're focusing, finding people, not a true search going, in drawers or under the bed or doing anything.
I think that's exactly right, Your Honor, with respect to the scope of what the officers were asking to do. But critically is that the trial court, having examined and reviewed all of this evidence, made as a factual finding that Ms. Brewer's understanding is that that was a request. It was a request for consent. And that wasn't a clearly erroneous finding, and therefore it should be affirmed.
Okay, and then I want to go back to what is she consenting to? Because the Creamer says, may I come in? But then he's followed in by the officers.
So
And may I go down the hall? But then he's followed by the officers. I'm just trying to think about when we have these cases, we're giving guidance to lay persons about what's respectable, what's allowed, what the police can and cannot do. And so I want to know what you perceive her to be consenting to.
So I'll focus first, Your Honor, on what happens inside the apartment. Our position that I'm happy to address if the court has questions about it is that anything at the entry was not properly preserved. But certainly the issues inside the apartment we believe were preserved. And that's what we believe the court should be addressing here. Inside the apartment, at the time that he's asking, you're correct, Your Honor, he says the word I. At that point, however, there are all the other officers standing there in his presence. There's no argument made to the district court that she would have understood the scope of the consent only to apply to the officer asking the questions, not the other officers there. So I think that readily explains why the district court didn't make an express finding on it. But so here on review, the question is whether any reasonable view of the record would support the district court's denial of the claim. And certainly it would not have been clear error for the district court to have found implicitly that the request applied to all of the officers, or at least more than one of the officers who had already entered the apartment. Otherwise, why would she have thought they were there?
Well, we understand why they were there, because they're flashing arrest warrants that she never sees, right?
Well, so the arrest warrants aren't presented to her. And I did want to actually clarify as a matter of sequence that there's no reference to a warrants until they're inside the apartment, just as a factual matter. I think there was some confusion about that.
We've
But-
drawn a line of demarcation on consent to entry and consent to go down the hall.
And so focusing on what happens again inside the apartment and the reference to arrest warrants, I do want to expressly address that point because I think it's important to say that we don't believe that Bumper resolves this case. Schneckloth makes clear that the issue of voluntary consent is a totality of the circumstances test. And there's nothing in Bumper that's to the contrary there. Bumper doesn't say that once the word warrant is spoken in any way, shape, or form that the case is just over. In fact, Bumper goes through all of the other reasons why that scenario was what it calls instinct with coercion. Given that the individual was alone, it was an elderly woman, she was at the end of a mile-long road, it was a Black woman being confronted by 4 white police officers in the 1960s. All of those factors would not have been important to the court's decision if the word warrant alone resolved the case.
But when you refer to 1960s, I'm not seeing with what's going on around the world so different, so.
I understand Your Honor's point that those issues haven't gone away, but I think my larger point is that the court was looking at a totality of the circumstances.
So, Mr. Cahill, you said that the district court found that Ms. Brewer's understanding was that Officer Kramer was making a request for consent. What would you point to as the strongest such finding? where she made that finding, that he was not asking, can I go down the hall and look for them, as I've said, I need to, but that you characterize it that she understood that he was asking for her.
So I would point specifically on JA 173 and JA 174. On JA 173, in the context of discussing the interactions inside the apartment, I'm looking at lines, starting on line 17, that the trial court said, it is abundantly clear from the conversation on the video that he was asking and not directing or ordering her. I think that's about as clear of a factual finding as we can get. And then on JA 174, the court follows up again and says that tellingly, Ms. Brewer appeared to understand it as a question, and then goes through the reasons why, and actually follows up on JA 175.
So what about that is not equally consistent with acquiescence to a claim of authority?
Well, so I'm happy to answer that, Your Honor, but as a premise, I want to emphasize that the question here isn't whether it's equally consistent. If there's two permissible views of the evidence here, the trial court's factual finding by definition would not be clear error. The question is whether the finding as a voluntariness was clear error.
But this relates to whether the district court made a legal error with respect to Brewer, so I'm getting there. But
sorry.
all of that is, could be acquiescence to a claim of authority. Now, the district judge set aside Brewer, and the question is, Bumper, did she correctly do so? She distinguished Bumper as a case in which, quote, the police sought consent by alluding to a warrant that did not exist, right? And she says, that's not this case, right? And she says the critical fact in Bumper was that the police were alluding to a warrant that did not exist. And that fact is not present here. And then she emphasizes a couple of times that he's candidly describing the warrant, and what he's saying, she says, is that I have search warrants. But that's wrong, right? In Bumper, the existence or not of a warrant was not critical at all. The holding turned on the fact that there was a claim of lawful authority, right? And then talks about the effect that such a claim, putting aside whether there's a warrant or not, which might be a separate, malfeasance on the officer's part, but just in terms of the subjective understanding of the person whose home it is, Bumper's holding doesn't depend on the actual status, but the district judge seemed to think that it did, and so she set Bumper aside once she's thought that, and she's no longer looking at the question of acquiescence to a claim of authority. She's only looking at overcoming someone's will.
So Your Honor, I would disagree with that characterization of what the district court does in this respect. So first of all, I would say with respect to Bumper, I don't think the district court was wrong to point out that distinction. There are cases that look to whether or not there was some level of deceit involved. I do agree with Your Honor that was not the be-all end-all of Bumper. But the district, where I disagree with Your Honor's characterization of what the district court judge did is that the district court did not then drop the question of acquiescence versus consent. What I was pointing to on JA 175 again, the district court actually frames its finding in those terms. It says that, it's based on how Ms. Brewer reacted to what Officer Creamer said, it did not appear in context to be an assertion of authority that he lacked, but rather a plea. Could I just look? The district court is making a factual finding there that she did not interpret this as an assertion of authority that I can look regardless of whether you agree. But it's a factual matter that she understood it as a question.
Well, but that exactly actually cuts the other way, no? Or arguably it doesn't. I'd be interested in your response. It did not appear in context to be an assertion of authority he lacked, but it actually is an assertion of authority that he lacked. That's why, as Ms. Bhatti said, that's why we're here on consent, not on the execution of a search warrant, right? He didn't have authority to go walk through and look for the people named in the warrants, right? The warrant didn't give him that. You acknowledge that, right?
That we're certainly not relying on the warrant for justification to look through the
Because
apartment.
you can't, right?
Yeah, the record would not.
It says it did not appear in context to be an assertion of authority that he lacked. She's acknowledging that someone in Ms. Brewer's position would think he's made a claim of lawful authority. And then she's like, she's not being confrontational, she's not being, struggling against the authority that she thinks he's asserted. But, she clearly thinks that he's asserted the authority to walk through. I can't go back to PG County unless you let me do this.
And so here's where I would push back, Your Honor, is that the district court repeatedly, and on both on J173 and 174, says that based on the district court's factual findings in the entirety of the circumstances, the entirety of the encounter to that point, and specifically also looking at the nature of Ms. Brewer's reactions, that the district court made a factual finding that she was understanding that to be a question. That's inconsistent with her understanding it to be an assertion of authority that she had to obey. And the district court said she understood it as a question. And for voluntariness, that's the critical question.
Not to be, I mean, if somebody's asserted lawful authority and then they say, so can I perform on that authority? The fact that someone is going to say yes, rather than, I'm going to call my, friend with a gun to come and chase you out of here. Like the fact that there's sort of acquiescence to lawful authority doesn't mean that this isn't a bumper case.
Respectfully,
She's polite, he's polite, commendably so.
If the district court had found, Your Honor, that Ms. Brewer's reaction was an acquiescence, then this would be a bumper case. But the district court didn't find that. It found the opposite. It found that she understood it as a question that was voluntary, that she had, that her will was not overborne. The district court.
But then when you say the district court did not find this as a case of acquiescence, I think that's some of our point. There's a distinction between the voluntary consent and acquiescence, and you need to find if there was legal error as to her not having a consideration that it's one or the other.
Well,
Discuss
so,
both.
respectfully, Your Honor, I would say that the fact that the district court found it to be a scenario in which Ms. Brewer understood this to be a question that she had, that she was not being ordered to obey, and as a matter of her own volition, agreed to accommodate that request.
Right.
That takes this out of bumper.
Does it? Because I know that under Schneckloff, there doesn't have to be, the officers don't have to inform the homeowner that she has a right to exclude them, right?
Right.
But if the homeowner believes that the officer is making a claim of lawful authority, then you don't need any overbearing, you don't need any sort of force or threats or, diminished education on the part of the homeowner. Somebody makes a claim of lawful authority, then it seems to me that as a factual matter, there's a different set of findings that one would make to nonetheless, the homeowner acquiesce. Like there's an Eighth Circuit case where it's like, you don't need no warrant, you come on in, I got nothing to hide. In that kind of situation, the notion of acquiescence is to the side. I don't see findings here though, where Ms. Brewer is making any kind of sort of supervening consent. You may have authority, you don't need authority with me, nothing like that here.
So again, Your Honor, I think the key is that the finding was that she viewed it as something that she had the option to either agree to. That the judge, I think the word the judge used is that she.
Where do you find this option, that she viewed it as an option?
So I would say that on JA 175, the judge said that the judge made a finding that she viewed it as a plea. I mean, a plea is something I feel like by definition that someone can either accept or decline. If someone's asserting their authority, I don't think that could properly be described as a plea.
Well, if you say, come on, let's not make this difficult. I have an arrest warrant. The arrestee is standing in front of me. I'm saying, can we make this easy for both of us? I have a job to do. I appreciate,
And I think the key here.
Making consideration, just to piggyback off that it always has to be, your will is overborne, or there's a strong urging or coercion or something bad, beating you over the head with it, as opposed to befriending you and, using your niceties to get to what you really want to.
Well, and so to be clear, I think the will being overborne as a term of art, Your Honor, would apply to both scenarios. The question is whether the person viewed it as a volitionary and voluntary consent. But I also want to emphasize here, Your Honor, we're not arguing that certainly bumper would preclude us from arguing that in any case where someone referenced a warrant, that there could not be a finding that led to an acquiescence. But that isn't what the court found here. The court made factual findings that were not clearly erroneous, as long as it was a permissible view of the evidence based on what Ms. Brewer did.
absolutely, I appreciate that correct statement of the legal standard, but there's no finding. The district court is sort of careful to point out that in the court's view, that Ms. Brewer appreciated the distinction between a search warrant and arrest warrant, and that Officer Creamer made clear to her that these were arrest warrants. And so I think the district court thought that was important because she thinks there's no false, she thinks it's important to distinguish bumper, that here there's no false claim of authority. But the district court, as far as I can tell, did not make any finding that Ms. Brewer knew or thought or understood that an arrest warrant does not empower police to search inside a third person's home for the arrestee. And if she doesn't know that, then even accurate reference to a search warrant could easily have been understood by Ms. Brewer as a claim of lawful authority. It seems like that's the strongest, most obvious understanding of his proffering an arrest warrant, saying, just let me look around. I have to go back to PG County. And unless she understands that she has any choice in the matter.
So, and again,
This woman standing there in her nightgown at 6-something a.m. with 7 armed officers around her.
not to go around in circles, and I want to get to the substance of what Your Honor asked, but
Focus on
yes.
that. You don't see a finding by the district court that Ms. Brewer understood that the warrant that Officer Creamer had, the warrants that he had, did not authorize him to cruise through just to look and see if the named suspects are there.
I agree the district court didn't make a finding.
Made no finding.
In those terms, Your Honor, but if I could
In
finish.
any
Oh,
terms?
well, I believe that that's implicit in the district court's finding that she viewed it as a plea. If she had not viewed it as, if she had understood him to be asserting that he had authority to do it, whether she gave her permission or not, that would be inconsistent with the district court's finding that it was a request and a plea. And so certainly the fact that the district court made those findings, I think implicitly would have rejected that interpretation. And again, the question here isn't whether anyone could have interpreted it the way Your Honor presupposes. It's whether the district court clearly erred by finding that in this case, under these circumstances, Ms. Brewer interpreted it that way. And our position is that the court didn't clearly err by making that finding. And we think that's supported by all of the factors that we outlined in our brief and have outlined here. I notice.
Mr. Kayla,
Oh,
I
yes.
have a factual question. Is there anything in the record that indicates why Ms. Brewer didn't testify here? Is there anything about,
I am not aware of that, Your Honor. I do see I am over time. If there are no further questions, we would otherwise rely on our brief in particular with respect to the fact that we strongly believe that any claims involving the entryway were waived and the other issues that have previously been addressed. And we'd ask this court to affirm the district court's judgment. Thank you, Your Honor.
Is there any reserve time?
There were 2 minutes reserved and none remaining.
All right, well, we used up all your time on direct questioning, but you may use your 2 minutes for rebuttal if you'd like.
Just very quickly, I wanted to clarify, we're talking about, I think there was a attempt to distinguish between entry and search, but I want to just make clear that those factors at entry, all of those factors are still relevant for determining the totality of the circumstances for purposes of the search. The time of day, the number of officers, the manner in which they entered, the manner in which they refused to answer her questions, the insistence, all of that is relevant to create that atmosphere that essentially, those stealthy encroachments, as Schneckloff put it, backed her into a wall, and then when you had the seven officers, flanking her and impeding her movement, that's all relevant for purposes of determining whether or not she gave unequivocal and specific consent. And that is the standard. And here we are, trying to figure out what's in her head and how she took the word need or warrants. And there's a simple way to fix this. And it's the government asking her, any one of those 7 law enforcement officers simply asking her, do I have your consent to search your apartment? And that would have solved this. And
We
instead
agree
they
with you.
didn't.
What's the relief?
The relief is we're asking the court to vacate Mr. Glover's conviction and reverse the denial of his motion to suppress and
And then I
remand his
thought your
case.
plea said, and send it back to the district court for further proceedings, which would refer to what?
Well, we're asking for the court to vacate his conviction. Obviously, without a gun, we have no conviction here. And so that's what we're
There's
asking
no
for.
retrial or anything.
No
I just
retrial.
was wondering what the further proceedings.
Oh, yes,
is
yes.
about.
No retrial. Yes.
Okay.
And then just one other thing on, again, the three gestures that the government refers to and the district court refers to, none of those rise to the level of unequivocal specific consent. I mean, it's a little bit ridiculous to think that waving your hand or flicking on a light could even rise to that level after the law enforcement officer, after Officer Creamer has stated, "I've got warrants, I need to search your home." And we cite a treatise, a quote on page 29 of our reply that is very applicable here. Because of the officer's claim of authority to search, Ms. Brewer's conduct in opening the premises was no more indicative of voluntary consent than acquiescence to the police claim of authority, accompanied by an effort to minimize the damage to the premises and degree of privacy intrusion. That's exactly applicable here. There's nothing in the record, there's no finding, and it's unreasonable and clear error to think that that this would rise, that Ms. Brewer's reaction, those three gestures would rise to unequivocal and specific consent under
Is there
Lindsay.
something short of vacating? In other words, there's been a lot of talk about the voluntary consent versus mere acquiescence. That would seem to be a legal error. So is there something?
I'm sorry, could you repeat that?
Is there something short of vacating the conviction? Because there was a lot of discussion about mere acquiescence versus voluntary consent and further findings by the district court.
Yeah, I mean, Your Honor, something
I'm not
short.
asking you to argue against yourself
Yeah.
because you want a full conviction vacated, but I'm
Right.
asking, we've spent a lot of time about whether the factual findings were sufficient to make
Right.
that distinction. And
Right.
so do you see a potential remand if it's short of vacating the conviction?
Well, we're asking for a
I mean, I know what you're asking
vacating,
for, but I'm
yes.
just saying, is there something short of that
I mean,
as an option?
I don't think so, but given the legal errors of this that we are arguing, we're asking for vacatur.
Because you think that if we find that there is a legal error, that still leads to vacating?
Yes, Your Honor. Absolutely. I mean, there's no, the way, we're asking this court to vacate because there's no basis for this conviction. And so, the district court committed these legal errors. And as a result, the fruits of the search was unlawful, the fruits need to be suppressed. And there's just simply no basis for this conviction. So we're asking for a vacatur.
Okay.
Thank you. The case is submitted.
You see.
Case number 23-1348, Petro Inc. petitioner versus Federal Energy Regulatory Commission and United States of America. Mr. Meinsinger, the petitioner Petro Inc., Mr. Oduchi for petitioner ConocoPhillips, Ms. Hoff for petitioner TAPS Carriers, Mr. Ediger for the respondent, Ms. Marcial for the shipper interveners.
Morning, Mr. Meinsinger.
Morning.
Speak
May it
when
please,
you're ready.
okay, may it please the court, Ken Meinsinger for Petrostar. I'd like to reserve 1 minute for rebuttal. In 2016, this court found there had been minimal investment in cokers in California, but the market situation has gotten much worse, with California refiners now retiring cokers due to what they themselves call a low profit environment projected to continue for years to come. Given that environment, the 20% return in the Quality Bank is clearly too high. And similarly, the perpetually increasing $700 million Quality Bank investment base is also too high because, among other things, it assumes California refiners are building costly new cokers instead of retiring them. The Quality Bank then compounds those two errors by requiring Petrostar to pay for a costly 21st century coker, even though the Quality Bank only gives Petrostar the inferior output or yields of a less expensive 1960s coker. Incredibly, FERC even ignored the author of those yields, Mr. Geddes, who testified that the yields should not be used here because they are for much older cokers. Now, most of what you're about to hear from FERC and the other parties to try to justify the 20%, yes,
Can I ask you about your mismatch theory?
certainly.
So you're concerned that FERC is using the capital costs of newer cokers while relying on the yields of older cokers, and there's sort of a mismatch. So I understand that argument, but FERC says that that these calculations actually reflect what's happening in the real world in terms of both yield and cost. So even if there's sort of a theoretical mismatch, why would it be unjust and unreasonable to rely on values that essentially reflect some underlying real world reality?
Because this is a real world mismatch, not a theoretical one. When you look at the evidence, there's only 14 cokers left
No,
on
but
the
is
West
Petrostar-
Coast.
Is Petrostar disputing the fact that these numbers reflect the actual yield and costs?
We agree that these numbers reflect the 12 cokers on the West Coast that are older, much older than this hypothetical coker, which was built in 2000. The two newer cokers on the West Coast have much higher liquid yields, consistent with what we've proposed. So in fact, what FERC is doing here is actually the opposite of reality. We've paid for a newer coker, and yet we're not getting those yields. And the record shows that. The two newer cokers have yields consistent with what we've proposed and with what our other witnesses, including Geddes, have said are consistent with newer cokers. So
The two newer cokers are just a fraction of the existing cokers.
and that's right. And FERC calls that cherry picking, but that's the only real apples to apples comparison. It's not just those two, by the way, Judge Rao.
Mhm.
The record is very detailed, involving cokers across the world, which we cited to in our briefs to FERC. Now, if I could, on the 20% issue, most of what you're about to hear to justify the 20% involves mere projections, okay, of what refiners hope to earn, not what they actually earn. And on very tiny projects, not comparable to a $700 million coker. And that's all they have in the difficult California market. We proposed using the refiner's weighted average cost of capital, which is only 7 to 9%.
But
There's
that's across the industry. It's not.
That's
dealing with
right.
Resid. And that just seems like a very different enterprise. At
Important-
least FERC found that. And
Well, importantly, there is no evidence of actual coker earnings on this record. Why? A coker is an integrated part of a refinery. You can't separate out the coker earnings. So
or there's not access to confidential business data. It doesn't mean they couldn't separate it.
they're integrated, and you really can't, you could go through some complex cost allocation, but that frankly would be a fool's errand. And so what you have here is FERC has tried to manufacture coker earnings in two ways. First, it's used something called hurdle rates and other projections. Hurdle rates are just what a refiner hopes to make. And by the way, those are refiner level hurdle rates, not coker hurdle rates, okay? One example, Phillips 66. We discussed this in our brief. It has a 30% hurdle rate. The same Phillips document where FERC plucks this out as evidence, Phillips talks about how actual refiner earnings of it and 4 other major refiners are only in the 5 to 12% range, nowhere near the hurdle rates that it uses. Similar for Marathon, 20% hurdle rate. It's already retired the coker, which clearly didn't meet that hurdle rate. The court has said we can't value cuts haphazardly. What could be more haphazard than using what a refiner hopes to make instead of what they actually do? All we have
But what are the inputs
is
that,
actual returns for refiners as a whole.
but what are the inputs that you're going to propose for setting this alternative cost reduction?
We propose using the weighted average cost of capital, very similar to what FERC's use. It uses for pipelines and utilities like the Constellation
But how's that going to
Mystic
project
case.
for inflation?
Well, inflation, that is used in the formula to inflate the investment base. And that has doubled the cost of the coker to $700 million. We have a change in circumstances, though. No one would build a new coker in California today. It's unthinkable. And the other thing, Your Honor, is in terms of inflation, the original $350 million cost of this coker, it's a sunk cost. Sunk costs, like the principal on your mortgage, do not increase.
Is PetroStar basically saying like 20 years ago, this was all reasonable and now no one's building any new cokers, and so we just shouldn't, factor in these capital costs into the pricing mechanism?
We're saying, Your Honor, there have been major changes in circumstances. We are not seeking to eliminate any capital cost recovery. We're saying instead of the 20%, you
So
should
you
use the
basically want to
WACC.
reduce the capital cost recovery to something exceedingly low.
It should be reduced to something much lower for a couple reasons. I've already mentioned no one would build a $700 million coker. That doesn't comport with reality. And the reality is we've paid for the cost of this $350 million coker more than 6 times already. It'll be more than 18 times if this isn't changed by 2050. And so this court has recognized in quality bank cases and elsewhere that a rate is subject to change circumstances. We have that in abundance here.
You're treating this though as if it's like cost of service rate making, and it's not. It's a projection based on a very, frankly, problematic raw material. What is gonna, make it going business proposition for somebody to either build or maintain, run a coker? And so it's just an analytically, the cost of service way of looking at this. And I grant that the references to capital, it isn't about, the depreciation of a capital resource. It's about what would it take for this to continue to be a going concern? Because we're
Sure.
talking about
But
a market value.
We do think you should use the weighted average cost of capital because the quality bank is based on costs. Even if you didn't do that, if you wanted to look to profits instead, something that's not rate making, those are low, 5 to 12%. And then in terms of the investment base, Your Honor, we have to look at what has changed here. The costs have been fully recovered multiple times. It's a sunk cost. It probably should have never been increased in the first place, but particularly now that the market has changed, look at California. No one would or probably could build a coker or a coking refinery there now. So we have to, FERC says you need to reflect market reality. The market reality is that the cost of coking is much lower now.
Does
So
anybody, any major refiner endorse the 7 to 9% CFR rate?
I'm sorry, Your
Does
Honor.
any major refiner endorse the 7 to 9% CRF rate, method?
Well, they haven't endorsed it, but these, the 7 to 9% weighted average cost of capital is determined by third-party financial analysts, the same ones that use to set returns in pipeline and electric utility cases. This is the CAPM model. So the refiners haven't endorsed it, but the information is based on third-party objective estimation of what those capital costs are, Your Honor. If I could just make one point about remedy.
I guess,
Sure.
it is PetroStar's burden to show that the existing rate is unjust and unreasonable.
And we feel
Not
like,
just to say that like there's a different rate that would also be just and reasonable.
agreed, but we feel like we've done that. The 20% is higher than either the cost of capital or actual refiner profits. There are no such thing as coker earnings. I want to say one thing about the coker earnings they've manufactured. It's important. They rely on a proprietary 2 proprietary models. FERC has no idea the basis for those models. And in fact, FERC's own staff rejected them for that reason. The alleged Coker margins also disregard 2 of this court's opinions. They're relying in significant part on the price of fuel oil, which this court rejected in Oxy and in Exxon. They also continue to rely on margins that exclude capital costs. They have not sufficiently explained that. Platts says they exclude capital costs. And finally, and this is really important, those 3 reasons are enough to reject these alleged margins. But the 4th reason, they allocate all the incremental profit of a coking refinery to 1 unit, the coker, and ignore what they themselves in their order in discussing the anomaly say are these other units of the coker. Look at paragraph 35 of the order. They say it's the other units that take the intermediate coker products and turn them into real valuable gasoline and jet fuel. They don't allocate any of the profit to those units at all. So these alleged margins, they're just completely overstated. Thank you, Your Honor.
Morning, Mr. Ducci. Proceed when you're ready.
Good morning. David Ducci on behalf of ConocoPhillips. I'd like to reserve 1 minute. The proper functioning of the quality bank depends on assigning accurate relative values to the 9 ANS crude oil cuts. And the quality bank's goal is to assign a value to each cut reflecting its actual price as closely as possible. For the resid cut, there's no published market price, so it needs to be reverse engineered. You take the product yields that result from the coking, and you subtract from that the coker processing costs, which are made of fixed and variable operating costs, and the coker capital costs. The coker capital costs are derived by the CRF, the coker refining factor. That factor is developed as the type of financial return or cash flow that refiners will typically require to invest in a coker. It's designed to reflect earnings, an earnings metric similar to EBITDA, earnings before interest, tax, depreciation, and amortization. Because the CRF is premised on earnings and expected financial returns, the only way to properly assess the reasonableness of the CRF is to look at the actual market-based evidence showing earnings, margins, and hurdle rates that the market is currently requiring to invest in a coker-type project. Here, FERC got it exactly right when it said Petrostar had failed to meet its burden to show that the CRF should be reduced because it looked extensively at that market-based data.
And how have you met your burden?
The
to show
critical
that
error
it's
here is that every piece of that market data that they used to reject Petrostar's analysis was never brought to bear on our analysis. Paragraph 178 is the entirety of the analysis saying that ConocoPhillips did not meet its burden. Yet, the record and the agency itself in its findings indicate and show that that's a false premise. For example, the presiding judge's ID at paragraph 146, pin site JA0470471, specifically found that ConocoPhillips witnesses justified a quality bank CRF of well over the current 20%.
Well, the fact that ConocoPhillips has shown that another rate might be just and reasonable doesn't also mean that FERC's rate is unjust and unreasonable. So those things aren't necessarily equivalent, right? You can have we have lots of cases saying that, the just and reasonable rate doesn't, whether those are, you may disagree with them, but, it doesn't have to be the most accurate rate. It just has to be just and reasonable. And you
Correct.
have to show that it's unjust and unreasonable.
That's correct. And part of that here is that the quality bank puts the responsibility on FERC to show that and get the value as close as to the market value as possible. For instance,
Where does it say that it has to be as close to the market value as possible? Is
You're-
that the only thing that would be just and reasonable?
yes, your last order in Petrostar v. FERC also indicated that. And from the very beginning, the quality bank's goal is to get the value as close as to the market
Maybe
value
we
as
should just
possible.
have the private market then figure it out. You have market pricing, no FERC pricing at all.
Well, actually, FERC's not pricing it, right? We are looking at the market. For all but 3 of those cuts, you're looking at publicly posted market prices. For resid, you have to pull it back and reverse engineer it. And here, every CRF in the record that was based on the market-based evidence is above 20%, which means
20, I thought the cash flow model from the trial staff was a CRF of 22.26.
22.26, and that's 11% higher than the original 20%. And we calculated that. FERC did not did not dispute any of our calculations on the record. That's a $29 million over recovery annually. And that cash flow analysis we actually looked at, and we said it's artificially low because of certain problems with the inputs to that.
But they also
FERC never
there are
addressed
hurdle
those
rates
questions.
Estimates from 15 to 30%. I mean, there's some inexactitude given the lack of the precise data that one would want, and that this is has to be reconstructed based on models and inferences have to be made. So are you arguing that the difference, you are arguing, I gather, the difference between the 20% and the 22.25% is it's arbitrary and capricious because it's unexplained?
We believe that's unexplained because, again, that overvalues the resid value by $29 million annually. But more importantly, is the fact that all of the evidence that FERC used to reject PetroStar's argument was never brought to bear on our question on whether it should be increased. They only referenced one cash flow analysis. Now, if you could, look at page 20 of our opening brief. And it's a graph. It's the very first graph. And that depicts exactly what our problem is here. And I'll let you get that out before I talk about it. Now, that may have some confidential information, but I am not going to talk about any of the confidential information. I'm just going to explain what this graph is showing. Do you all have it? Okay. So if you look near the left, there's a current methodology of 20%. That's the current quality bank methodology. And that's the current CRF. And what ConocoPhillips witnesses did, everything to the right of that, that's the market-based evidence in the record. Their hurdle rates, their internal rates of return, they're the margin data from Platts, the margin data from IHS, all converted to CRF so that you can look at it on an apples-to-apples basis. All of that information to the right of the 20%, FERC relied on to dispel the inappropriate claims of PetroStar that it should be, that the capital recovery factor should be reduced. And that's to the left of the 20%. All of the evidence to the right was never even brought to bear on whether the CRF should be increased. Simply the 22.26%. FERC just simply says, on balance, we haven't met a burden. On balance actually requires a balancing. And right now you've got the 22.26 and the 20, but they completely ignore all of the rest of the market-based evidence they found reliable.
Market-based evidence, how much of that is based on proprietary information that can't be verified?
I would say can't be verified. You can verify it. FERC can verify it. They can subpoena it, and they did. So they can verify that data. And those, like for instance, internal rates of return, those are the AFEs that you see there, where they're listed as AFEs. Where you're seeing hurdle rates, those are public. And remember, a company, let's say like the record has Valero's evidence publicly. They're building a $1 billion coker and their hurdle rate is roughly, I believe, 25%. That's public. They're telling their investors they're going to invest $1 billion because they think they can get that 25%. That's not an ask for some type of a wing and a prayer. These things are, hurdle rates are actually well thought out, gated plans. The record has a DOJ and EIA study, which specifically says, yes, it's ordinary to use hurdle rates to make these investments and to look at them and qualify them and decide on them. And that for the most part, you're within 5%. But my question here is, in looking at whether it should be increased, FERC needed to actually balance that and actually apply the evidence.
It did balance. I mean, it considered your claims and it considered, what would it mean to wholesale rely on hurdle rates, projected earnings, FERC decided that's inappropriate. And moreover, if FERC adopted the 30% CRF that you proposed, that would undercut some of the responses that FERC relied on to Petrostar's arguments. So it's taking people, challenging from all sides and doing what it thinks is the best with all the different criticisms that it's getting.
However, Your Honor, I don't believe that's correct, and I believe that FERC is drastically inconsistent. As I was saying, if you look at opinion 588, and it's paragraph 143, JA site 62, they cite CPI, ConocoPhillips witness Flessner demonstrated that CRFs derived from Platts West Coast coker earnings far exceeded Quality Bank's CRF of 20%. Then commission found again, relying on ConocoPhillips evidence, and this is paragraph 144, pin site JA 6263. And they quote, "The record includes extensive testimony that refiners are recovering coking margins above the current per barrel CRF of slightly under $10. Again, citing ConocoPhillips witness of the Laughlin and Flessner. And finally, at opinion 58 at paragraphs 155 and 171, JA site 68, 69, and 77, they cite ConocoPhillips evidence showing that West Coast cokers historically had higher CRFs and earnings than the Quality Bank coker. This inconsistency is arbitrary and capricious. They have yet to actually apply and to address the question whether it should be increased based on the market-based evidence, which their own staff said was 22.26, which is higher. I say I'm over.
Yeah. All right.
Thank you.
Thank you. We'll hear from Ms. Hoff. Good morning.
Good morning, Your Honor. May it please the court. Amy Hoff on behalf of the TAPS carriers. The issue of whether the administrator violated Section 3G5 of the tariff is not a question of whether the TAPS carriers have complied with or violated the filed rate doctrine, which is how FERC has attempted to portray this. This is purely an issue of tariff interpretation. And in this case, there is only one reasonable interpretation of Section 3G5. And that is that the administrator will monitor the common stream through periodic testing, but that he will replace the resid values that are set forth in the tariff only if he determines that there is a significant change that will have an impact on the value of resid. And I will note that this is the interpretation that the administrator has applied without difficulty for almost 20 years.
Does the tariff say there has to be a significant change?
Your Honor,
Is that just the understanding? Is that actually in the tariff?
it is in the tariff, Your Honor.
Where is
And if,
that?
I'm sorry?
Can you give me a site? for that?
Yes. If you look at, it's in, I think the language is set forth in the initial decision, and that's in JA 0554. And I will note this is an excerpt of Section 3G5. It's not the entirety of the section, but the first sentence that you see in the quoted section, which is in paragraph 375, it states that the Quality Bank Administrator shall have the discretion to retest, when he believes that there may be a change in the common stream that will, and I quote, significantly affect the resid component unit values. So the word significantly is in fact set forth in the tariff.
But then isn't this the provision that is under the prospective tariff amendment that once the Quality Bank Administrator elects to retest, that should all be taken into account? So the significance kind of drops away prospectively.
Your Honor, that is certainly how FERC has interpreted it, right? Is that the discretion, the quality bank administrator's discretion only comes into play after, right? His only discretion is whether to test or not to test, right? And it's, if he does test, then under FERC's interpretation, then he is required to use those test results. But I will say that is, right, that interpretation I think is inconsistent with the totality of Section 3G5. Primarily because I think if you focus on the second sentence of this excerpt, which FERC has done, it effectively reads the first sentence out of existence, right? In other words, it sets aside the quality bank administrator's discretion to do anything. And from a practical perspective,
Understand that argument though, because the significantly effect goes to whether, so the administrator for some reason believes that there might be a significant change. And so he elects to test. And so that second section, the second sentence seems to be the one that's relevant to what he then has to do once he has elected to test.
the issue, Your Honor, is a practical one. And that is that, right, so the quality bank administrator has been tasked with monitoring the common stream. I think that's very clear if you look back at the 2004 initial decision, which was the genesis of the section of the tariff. And the issue is that the only way the quality bank administrator can monitor, right, the only way he can have any idea whether or not there has been any change in the common stream is to test. You can't look at the crude oil and decide, okay, the resid values have changed. You have to test in order to make the initial determination of, okay, is there a reason to think that the results may have changed?
I mean, what you say makes a lot of sense, you know, in terms of, well, we shouldn't update the formula unless there has been some kind of real change. But that just doesn't seem to be what the tariff says.
And Your Honor, I think certainly the tariff is not, right? The tariff is not perfect. It isn't, right? It isn't. I will say, however, that I think at least for the last nigh on, 20 plus years, the quality bank administrator has interpreted the tariff in exactly this way. He submitted a memo in 2006 at the time that the Section 3G5 was implemented, indicating that he was doing monthly testing and that he would continue to monitor the common stream, right? And so this has been the interpretation for almost 20 years until this issue was raised by Petrostar.
And the formula wasn't updated during that time.
Well, what's in the tariff is the 2001, the resid properties that are set forth in the 2001 Caleb-Brett assay. And so the idea was, right, and if you go back and look at the 2004 initial decision, that they were going to use the 2001 Caleb-Brett assay as a starting point going forward until the quality bank administrator determined that there had been a significant change. And so that was supposed to be the starting point. There was going to be continuous monitoring, right? That was going to be done through periodic testing. And that can be seen, I believe, in paragraphs 1147 of the 2004 initial decision. And it was only then after the administrator had made a determination that there in fact had been a significant change that there would be a subsequent formal retest and the values would be updated.
So has the volatility in the resid properties made these individual monthly tests unreliable with respect to a pricing model?
Yes, Your Honor. And in fact, that is actually what the commission itself found. If you look at paragraph 79 and 80 of opinion 588, and that's in, let's see, that's the joint appendix 36 and 37. That's specifically what the commission said. So they found there that as described in the record, the current tariff language in section 3G5 places the administrator in a no-win situation that leads to unjust and unreasonable results. And then in the rest of that paragraph, they talk about all of the problems with using the results of the monthly tests and set forth in the original initial decision, not the 2004 initial decision, but the initial decision in this case. There are a number of graphs that begin on approximately paragraph, let's see, that it begins on approximately JA 545, and they show the 2001 Caleb-Brett assay as compared to as compared to the results of the monthly test. And they show the volatility. And that's what FERC is referencing when they're talking about this in paragraphs 79 and 80 of opinion 588.
And have you all conducted any kind of, like independent audits to determine the financial impact with respect to noncompliance?
Your Honor, I'm not aware of that. I will say, right, that the TAPS carriers and the Quality Bank Administrator administered the Quality Bank on behalf of the shippers and we have no financial stake in this. And so no, as far as I know, that analysis has not been done.
Just a big picture question. I'm just not sure how, following your logic, wouldn't it mean that shippers can ignore the text of the tariff if they have an analysis showing that it leads to unjust results? Like, how can it be enforced in the meantime?
I'm not sure I fully understand your question, Your Honor, but in terms of how the tariff can be enforced, again, so I think what the Quality Bank Administrator has done and what he was tasked with in the 2004 initial decision was to perform, we're going to start with the 2001 Calibret assay, and we're going to monitor the common stream, right? To see if anything changes that is going to significantly impact the value of resid. And again, the only way he can do that is through testing. And so the Quality Bank test the common stream on a monthly basis. They look at the resid, right? They look at the resid results. And, the resid results, they do vary, right? Significantly on a monthly basis due to differences, difference in the equipment at the lab, differences in the lab technician. There's sometimes just a lack of precision. And so and this is in the record, but the Quality Bank Administrator was looking for overall trends. In other words, is there a significant change in one direction, right? In one direction or another that is a sustained trend? And if so, then the Quality Bank Administrator would follow Section 3G5 of the tariff, say, I've identified a change that will have an impact on the value of resid, and then update those properties in the tariff. And so I think I don't know if that answers your question, Judge, but I think that's how they will, right? That's how someone can ensure that the goal of the tariff is met, which is to ensure that the values that the Quality Bank Administrator uses for resid are appropriately reflective of the values that are in the common stream. So I would just like to point out that I think it is, right, FERC acknowledges in opinion 588 that they have put their interpretation of the tariff has put the administrator in a no-win situation. And if you look, you can see that, and again, in paragraphs 79 and 80.
You're wrapping.
Oh, I'm sorry. Yes, Your Honor, I am. I will simply say, right, that I think FERC's interpretation contradicts basic principles of tariff interpretation that are set forth in the cases that are cited in our brief, as well as the cases that are cited by the commission. And based on that, we think their interpretation is illogical.
Say what you think the no-win situation is for the administrator? Could you?
Oh, yes. So the no-win situation is, and again, I think this is what FERC is talking about in paragraph 80, where they say this. The issue is that what they've said is that, okay, we recognize that that the tariff requires you, right, that the tariff requires you to monitor the common stream. And we recognize that the only way you can monitor the common stream is through periodic testing. But the language of your tariff also says that if you monitor and if you do testing, then you must use the results of those tests, even if those results are not representative of the common stream and therefore not just and reasonable. So I think FERC acknowledges that it's a no-win situation for the administrator, because we're going to violate the law on one hand by failing to follow the tariff. But if we were to follow the tariff, then that would also equal a violation, right, of the Interstate Commerce Act, because we would be using test results that were not just and reasonable, and therefore applying an unjust and unreasonable valuation to resid.
Has TAPS, have they sought a revision of the tariff?
No, Your Honor. There's been, well, let me back up. There certainly, right, the tariff
That's
has.
also an option, right? If this seems to produce strange results in a no-win situation.
The tariff has.
One possibility is to petition FERC to change the tariff.
The tariff has now been revised, right, in the wake of opinion 588. However, again, for 20 years since the tariff was put in place in 2006, this is how it was administered, and no one thought that it was producing unjust and unreasonable results. In other words, I recognize that in the opinion, FERC says, well, in their brief, FERC says, well, if it's producing unjust and reasonable results, then you can ask to modify it. But I think it wasn't producing unjust and unreasonable results, because even as FERC recognizes, the use of the 2001 Caleb-Brett assay continued to be representative, and so produced a just and reasonable valuation of resid during that period. And so there was, under the TAPS carrier's interpretation, there was no reason to seek a change to the tariff.
Thank you.
All right. Thank you, Your Honor.
May it please the court. I'm Scott Ediger, appearing for the Federal Energy Regulatory Commission. Thank you for hearing this case this morning. This case is primarily about the valuation of resid. No party, neither Petrostar nor ConocoPhillips, has demonstrated has demonstrated sufficient evidence to show that the methodology used to value resid results in an unjust and unreasonable result. Rather, the commission found, looking at the record as a whole, that the tariff accurately reflects the market value of resid, and it is just and reasonable. I would like to start briefly with the yield issue, and I'd like to point this court to two particular paragraphs that I think are very key to this issue. The first one is paragraph 53, JA 25.
What specific yield issue are you talking?
The yield, the base yields, and this will be wrapped up with the mismatch theory and all of that. And where I'd like to start is with paragraph 53, where the commission makes clear that the name of the game here is to get to mimic the typical West Coast coker. My friends for Petrostar would like us to look at particular what they consider high-performing cokers. And if I can diverge just for a second, the commission doesn't even buy that premise, because the commission notes that it's a lot more complicated than that, and that the newest cokers are not necessarily more productive than the oldest ones. But setting that aside for a second, the real important key here that we're after is to mimic the typical West Coast coker. What Petrostar suggests wouldn't get to that. They would only look at certain cokers, and we can't be sure that the crude oil is actually going to go to those cokers. This crude is going to go to the entirety of the West Coast coker. So that would actually create a problem if we were to adopt that theory. The second paragraph I would like to highlight is the actual facts of how the base yields reflect what's actually happening on the West Coast coker market. That's paragraph 54 at JA 27. The commission relies on the testimony of Flesner at page 125 and 127 to 133. And this is at JA 2516 and 2518 to 24, who looked at 8 West Coast cokers, and also the testimony of Ruckert at pages 54 to 58 and 60 to 65, JA 1648 to 50 and 3132 to 38 and 1651 to 52. And Ruckert looked at 12 cokers. Both of them concluded that the West Coast coking market has yields that are very close to what the base yields are in the tariff. So the actual mismatch, I would argue, would be to embrace Petrostar's theory of using particular cokers that they think are high performing.
So would you say that the mismatch is only theoretical and not a real world mismatch? Is that one way?
It is definitely not real world mismatch, and certainly I would rely on paragraph 54 and the commission's findings in that paragraph, and so there is no mismatch, and this ties into the theory about sunk costs and all of that, and I think both of them are are consistent, what the commission, both of those theories are consistent. We're using base yields that exist today, and we're also using a capital cost that is consistent with today's dollars. We're started with a base 2000, and the commission reasonably has applied the indexing to that base in order to bring those costs, capital costs, up to today's dollars. And in fact, as we pointed out in our briefing, at times that has actually gone down. So we're just matching the prices.
But does it differentiate based on technological improvements?
I would say it does account. First of all, again, the commission disagreed that the new cokers are actually any better, and that any technological advancements actually are available to any coker. And the commission made that finding. But then again, I would go to paragraph 54, and that the base yields again are actually very close to what's going on in the West Coast market.
About the TAPS carriers arguments.
Yes.
And the tariff interpretation there. What would be your response to Ms. Hoff's arguments?
The response is, I have a couple of points. I clearly, the commission said it's a no-win situation for the administrator, and but the commission also said, I would point the Judge Rao to footnote 176, and this is to paragraph 81 at JA 37. And the administrator didn't have to do any testing. And so this gets to your point.
This argument seems a little, I mean, the administrator is seeming to want to diligently monitor the composition of the stream. I mean, that seems, and was doing so for many years on a monthly basis. That does seem like something that the administrator maybe was required to do, or in the diligent exercise of his duties was performing.
Fair enough, Your Honor, and I appreciate it. I don't think the commission meant to indicate that the administrator wasn't diligent. This is just a disagreement about what this tariff means. I think my response is at the end of the day, the proper thing to do would have been to amend this tariff earlier.
Well, so I asked Ms. Hoff that, and she said, well, nobody, I mean, this was just what was being done, and no one suggested that it was inappropriate, so there was no reason to try to modify the tariff after so many, years of sort of constant practice.
I'm not sure that's an answer, because that no one thought to comply with the tariff. I'm not sure that's an answer. I think at the end of the day, we want compliance with the tariff, and all the commission has done here. And I think Your Honor sees in particular, the second sentence of the relevant language here, and it's pretty clear that that once a test is made, that it shall be incorporated. And I think the volatility that could occur in that situation, if that had been a problem, I think the proper response would have been to amend the tariff.
Dr. what's your response to Ms. Hoff's assertion that there's almost like a circularity built into those two sentences of the tariff? Because the only way that the Quality Bank administrator can tell if there's been any changes to test. So it's not like there's a reason to believe there's been a change and then testing goes on, and the reason to believe has to be that there's been a significant change. She's asserting there's no such information unless and until you test, and therefore the substantiality qualifier has to apply.
I guess
results as well.
I guess I would make a few points. I would go back to the footnote that says
Test it all.
it wouldn't have to test it all.
That's
That's number one. And then number two is there could be a lapse of time. If there isn't testing and then a year goes by or something like that, that might be reason. I think Your Honor is searching for a reason to test without a test. And so a lapse of time in that circumstance might be a reason to do a retest. And then the second sentence of that tariff is very clear. Once that's done, it shall be used in the tariff. And I also want to point out one other thing, and I think all parties agree that the testing here is just as credible, it's reliable. It's there's no suggestion that it was some sort of informal test or anything like that. And this is paragraph 74 at JA 34.
It's more that it can be variable and so FERC has resolved that by doing that.
Right. In paragraph 79 to 82, JA 36 to 38, the commission did amend the tariff. So to somewhat codify the existing practice of the monthly testing, but then do an annual update, which would address the volatility issue.
The annual updating is now part of the new tariff.
Yes.
Significant or substantial or not.
Yes. Could I back up and go to, I want to make just a few points on the CRF and in particular ConocoPhillips. And I think I just want to highlight what the commission has done in paragraph 178 and highlight some of what the commission meant when it looked at the record as a whole. And I just want to emphasize that this is a very long record. There are a lot of witnesses. The hearing was very long. Judge Hurt, she did a very thorough and excellent evaluation of all the evidence, and the commission had to grapple with all that. My friends for ConocoPhillips would like us to hone in on their particular evidence, but there was more than that. There was this commission staff, Zachary Ruckert's cash flow analysis, which resulted in a CRF that was 2.26, very close to the existing just and reasonable rate. And it bears mentioning as well that it is the burden on the proponent of a change to first demonstrate that the existing rate is not just and reasonable. And
why not just go for 22.26? That's been demonstrated to your satisfaction. And they point out that there's a non-trivial difference between that and 20%.
Judge Pillard, there's much more than that. There's the hurdle rates. And I also want to make a reference to the WACC, to the weighted average cost of capital. Sorry for that acronym. And the commission said in footnote 423 at JA 82 that the weighted average cost of capital is one source of data. And it also said that it was outweighed by hurdle rates and earnings. And also at order paragraph 169 at JA 74, the commission said that the weighted average cost of capital provides some information. And then again at paragraph 171, JA 77, the weighted average cost of capital is one data point. So the commission did not entirely dismiss this evidence. So there's staff witness Ruckert, there's the weighted average cost of capital, there's hurdle rates. So I'm circle back, Judge Pillard, to your question, why didn't the commission just go with that one data point? And I believe the answer is, there's so much more out there. And the commission explicitly said that when it referred to the extensive record and that was making a decision here on balance. And that's in paragraph 179 at JA 81.
It's a little analytically unsatisfying because it's sort of, I mean, you can see where ConocoPhillips is coming from. You're using these arguments against Petrostar, but then sort of saying, yeah, but there's a lot of static in here, so we're going to stick with 20%.
I think these are difficult. I think this is a difficult issue. And I think the volume of paper that we're dealing with in this case, I think that speaks to the grappling that the commission did and Judge Hurt did with this case. And
does this come down to that the information about how much is actually spent on coking is proprietary information? I mean, so that all this reconstruction of actual costs to come up with a reverse engineered market price is it because of proprietary information?
Well, it's an integrated process.
Right. So separating it out.
I think that must make it very difficult. But I can turn to I mean, the commission addressed the Platts data and the commission found it credible. And the commission considered PetroStar's arguments, trying to turn to those pages. And I think the commission is entitled to deference on that question.
There's a lot of paper, so FERC wins.
I would refer your honors to paragraph 158, and this is JA 70, and it's referring to both the Platts data and the IHS data, and they say they're well-known data aggregators, and the commission, and I think it's entitled to deference on this, said that their margins data is a useful metric for analyzing earnings. Thank you, Your Honor.
And lastly, we hear from shipper interveners. Ms. Marcial?
I pronounce it Marcel.
Marcel,
Yeah.
thank you.
Thank you. Thank you, Your Honor, and good morning. Lori Marcel for the shipper interveners. I have a couple points to make, but I would like to start by just responding to a few of the questions and comments that have been made so far. And I believe early on there was a question about market prices and how do we know this is supposed to be based on market prices? And that is a very well-established precedent with respect to the Quality Bank. I think Mr. Adducci referred to the fact that this court in its remand order said that the Quality Bank, the values assigned to each of the Quality Bank cuts are supposed to mirror market prices as closely as possible. And that principle goes all the way back to this court's decision in Oxy in 1995. And in our brief at footnote 7, we have a string cite where we cite a lot of the precedent. And so the FERC has always tried to apply those principles, as has this court. Mr. Meinsinger was talking about, and they've made a lot of claims in their briefs about how much they've paid, and they've paid for this coker so many times, allegedly. But FERC ruled correctly because FERC saw this for what it was. And FERC said, even if that's true, the coker continues to add value, and there needs to be a charge for that processing, because you really need to go back and remember what's going on here. So PetroStar is taking the crude oil out of taps. It's taking what it wants out of that crude oil, and it's rejecting and it's turning what it doesn't want into the common stream, right? And that includes a lot more resid. And it's in here saying, basically, we shouldn't have to pay for that. We're going to make that resid all the other shippers' problems.
So to be fair, we should pay less for that.
Well, we should pay 10 cents a barrel. That's what they're saying. So almost nothing, right? So that's what they're saying, and that's what's important. That's what you have to remember here. And there was never any expectation when this 20% capital recovery factor was adopted back in the days of Judge Silverstein and his order in 2000 that this was going to expire, okay? And the initial decision points this out at paragraph 115, 109, and 231. Because at the time Judge Silverstein adopted it in 2004, it was retroactive to 1993. And so that at that point in time, the coker already would have been paid for multiple times over. And nobody, including PetroStar, argued then, wait a minute, we shouldn't have to pay for this. In fact, PetroStar supported the 20% CRF.
How do we think about, though, the real world fact that they have suggested that no new cokers are really being built, or very few?
Well,
And so these are things that are, they've been built a long time ago, and that's a market reality as well.
well, the commission found correctly that, well, I mean, all that means is that the West Coast has the capacity it needs for coking. I mean, there are 14 cokers on the West Coast.
So is that a lot?
Yeah, I
Is
mean,
that good? Is that a lot of cokers? I mean,
and PetroStar suggests that, oh, well, there have been a couple of conversions to renewable fuels and that, and things along those lines. And they just take the fact that that's happened without any actual evidence and say, oh, well, that means cokers aren't valuable. There is evidence in the record, and we cite to it in our brief, and the initial decision, and it's at Joint Appendix 2605, and in our brief, we cite to it at note 41, where we actually got through a subpoena, we got some evidence, and the commission relies on it, about what the causes were for those conversions, and it wasn't the cokers. So you cannot look at evidence of some conversions or the fact that cokers aren't being built to say, oh, well, it's not valuable. Nobody's paying for coking anymore, because that is not true. In fact, the commission found very reasonably there were a lot of witnesses that testified to this, including Petrostar's own expert witness on cokers, Mr. Romero, testified that cokers are valuable. They are adding a lot of value because they're taking resid, which is literally the bottom of the barrel, and they're turning it into valuable products. Coking's expensive, and cokers provide a very valuable service. The fact that the initial decision found correctly that the fact that some cokers are no longer in service only makes the other cokers more valuable. That's what witness Leto testified to, and that's what the judge pointed to.
But if the resid value is really low, based on market data.
Well, it has no value until it's coked into
But who's
saleable
bearing the
products.
cost of that?
Who's bearing the cost of? Well, it has to be converted
Right.
by a coker into saleable products. And so that's what we're doing here is that's how it's valued. Because there's no market price for it, you work backwards. You start at the price of the saleable products, and then you have to deduct the cost of coking. This court has found that the cost of coking must be deducted in order to get all the cuts on an equal
You
basis.
say she says it's low value, and you say, well, it has no value. I mean, it has no valuation. Because
It has no-
the whole project here is figuring out what its value is.
Right,
before it's
in and of
processed.
itself, before it's cooked, right? It doesn't have a market price, but once
It's
it's, once,
never had a negative value or a pre-processing or a zero value. It has some value, it's just not enough.
well, there was a time, because through the history of the resid valuation cases that have come before this court, and, we've been litigating about this a lot for many years, where it can be, if you need to sell it or dispose of it, it has to be blended with fuel oil. But this court said a while ago, that's not an acceptable way to value it. That is way too inaccurate. We're not going to accept that. Go back and do it again, FERC. So I'd like to go a little bit to the mismatch point. That is a true red herring, okay? Because first of all, when Petrostar says we're paying for a newer coker, what they point to is equipment that Judge Silverstein added to make this a modern coker, because Petrostar is quoting this language from Judge Silverstein's order saying, we're going to make this a modern coker. We're going to bring these costs forward from 1996. And there's equipment that I want to add to make this a modern coker. Well, it was demonstrated, and the commission relies on this, as did the judge, and Petrostar's own witnesses admitted that none of that equipment increases yields. So whether it's a newer coker or not a newer coker, that equipment doesn't increase yields. And the fact of the matter
FERC
is,
relied on that.
and FERC did rely on that, yes. If I have it handy.
You can wrap.
Okay.
What does it mean to increase yields, though?
Well, when you add that equipment, it's not the kind of equipment that's going to enable the coker to produce when what Petrostar is saying is the coker a modern coker is producing more liquid, more of the valuable liquid yields. And none of the equipment that was added, that Judge Silverstein added to the coker to make it a modern coker, would have the effect. It was mostly for safety or environmental reasons or things like that, not anything that would increase yields. And in fact, Mr. Luca, who both the judge and the commission cite, he was coking expert that we sponsored, testified that, and Mr. Flessner as well, and Petrostar's witnesses agreed that the cokers operate to maximize, refiners and cokers, to maximize profitability. And that isn't always the same thing as maximizing yields, right? And there are many reasons that a coker or a refiner would not operate its coker at maximum level to just get increased yields, because as the commission found, the incremental yields that you're going to get are not as valuable. And there are detrimental effects to your coker for running it that way purely for the purpose of increasing yields. So it's a little more complicated than Petrostar would have you believe.
All right. Well, unless you have another point, we're ready to wrap up.
Okay. Yeah, I would like to just wrap up by saying, and I think this is something that, well, I know that my colleague, Mr. Editor touched on, but FERC conducted a very thorough review here. It was a 9-week hearing with 17 expert witnesses. When the court remanded this case, it identified a limited set of issues pertaining to the capital recovery factor for FERC to revisit. And FERC actually broadened its scope of review. It broadened its scope of review to include things that Petrostar didn't even appeal, like the yields issue. And it made a very thorough and sound, well-reasoned decision that the capital recovery factor and the yields continue to accurately be reflected in the PIMS yields, and that the capital recovery factor should not be reduced below 20%. Thank you for your time. I appreciate your indulgence going over.
Thank you. And now we have some short rebuttal. I think Mr. Meinzinger had reserved 1 minute.
Just have a few quick points, Your Honor. First, Ms. Marshall said resid has no value until it's processed. Neither does crude oil. You have to process it. You can't just put crude oil in your car. Second, Judge Rao, you asked Mr. Aducci about, I think, whether there was any visibility into the models. There is no visibility into the models at all that are used to construct these artificial coker margins. FERC has no idea how they're calculated. That's why its staff disavowed those margins.
There were subpoenas for some of that proprietary information?
I don't believe there were subpoenas for that information. Someone mentioned that the quality bank is based on market prices. True, actual market prices for cuts like propane and butane, not projections. There's lots of projections out there for the price of propane. We don't use those. We use actuals.
If we had the analogous market prices for the bottom 3 cuts,
Yeah.
I'm sure they would be.
Yes.
But we're in a different situation with.
We
respect.
are, but
The point is that we're not doing cost of service rate making. We're projecting a market.
and that's fine, Your Honor, but the 22.6 that you mentioned is based on purely projections, not actuals. And staff's own testimony is based on 4 hurdle rates, the average. Staff's own testimony says those are rarely achieved, citing the EIA and other evidence. They're rarely achieved. Much lower returns are achieved in reality. And so if anything, the hurdle rates are only substantial evidence of what a refiner would hope to earn. We can't base the quality bank on that any more than we would base, let FERC get away with some other judgment about something that doesn't comport with reality, like whether there's a need for a pipeline in New Jersey or not.
Need for a what?
A pipeline in New Jersey. There was a case, Judge Childs is nodding, but, FERC said there was a need for this pipeline, and you looked at the evidence. You didn't let it get away with that. There's a study there in New Jersey that says, no, we don't need a pipeline. And so we deal with actuality here, not just broad brush. The reality here is that refiners are closing refineries in California. Ms. Marshall mentioned the conversions. 2 major refineries have been converted to renewable fuels. When that happens, the coker's gone. It's not earning a thing. The refinery still is, though, processing soybeans or something. But that shows that, if anything, the 7 to 9% WACC is generous. Now, Judge Rao, you had a question earlier about how low Petrostar's calculated value is. But that only goes to remedy, specifically more about the investment base. If the court thinks our remedy is too low, we talked about several alternatives. One would be the original $350 million rate base, to go back to that, because clearly you don't inflate a sunk cost and circumstances have changed. If you think our proposal is too low, it's not a justification for the $700 million investment base, which is completely out of whack with the reality of this market, whether you used cost-based analysis to look at this or more of a market realities standard. Last thing I would say is Mr. Edinger said that the yields are reflective of a typical West Coast coker. Fine, we agree, but the quality bank coker isn't typical. It costs $350 million to construct. The typical coker was built in the 60s for less than 100 million. We're not getting what we paid for. And that's just unjust and unreasonable. Thank you, Your Honors.
Thank you very much. The case is submitted.
Thank you.
Oh, I'm so sorry. There was one more, and did you also, Ms. okay, we have a couple minutes here of rebuttal, sorry.
Thank you, Your Honor, and thank you, Judge Ray.
To comment on what a good argument did in your primary.
First, I'd like to say Petro Star 853 F3rd at 100 is the reference to as close to the market as possible. And that's citing Oxy 64 F3rd at 693. Mr. Ruckert talked about cash flow analysis 22.26. On our brief, we specifically point out that it's basically this pattern in dealing with ConocoPhillips arguments. We specifically challenged the legitimacy of the 22.26, said it was artificially low. We challenged specific inputs to that cash flow model. That was on our brief on exceptions. Trial staff did not oppose those exceptions. On opinion 588, doesn't address them at all. It just didn't address them at all. So the 22.26 has to have a check mark by it. We believe it's artificially low, and we believe our arguments to that will go directly to whether the CRF should be increased. Because if they're relying on the 22.26, and that's actually what, as we showed, if you corrected it, equals more like 30%, that goes directly to our argument. Next, counsel for FERC staff said hurdle rates as a reference to, hey, look at the hurdle rates in relation to the CRF. You got to remember that a hurdle rate is not a CRF. Hurdle rate is an expected return. The CRF is a cash flow analysis where you look at what is an investor looking for. It's an EBITDA value. It's a recovery of your investment, on your investment, and income taxes. They're two separate things. You can convert a hurdle rate into a CRF, and then you can compare the CRFs based on those hurdle rates. And that's what we did in that on page 20 in that graph. Mr. Ediger also said and told you Platts IHS data margin was very good data and it was well done. He forgot to tell you that that's ConocoPhillips' witness that he's relying on. And that data showed, as I indicated in my early arguments, that you could justify a CRF much higher than the 30%. It's just beyond my imagination where staff and FERC can say, we're relying on your data to show that a CRF can be justified much higher than 20%, and then turn around and say the same data that you just presented, that doesn't meet your burden to show that it should be higher than 20%. That doesn't make any sense. Lastly, he said that this case is complicated and it's large. Well, just because a case is complicated and large doesn't allow you to do arbitrary and capricious things like not apply evidence to the issue. And then lastly, I would note for you all, about 2.5 weeks ago, this court issued a case in Cigar Association v. FDA, case number 23-5220, 2025 Westlaw 286514. Strikingly similar to this case, where this court reinforced the fact that if you base your decision on a false premise, it's going to be found arbitrary and capricious. And if you don't apply the relevant evidence to the question, including when you're choosing between options, you're going to be found arbitrary and capricious. Thank you.
Thank you. Ms. Hoff.
Yes, thank you, Your Honor. So the commission is advocating an overly literal interpretation of Section 3G5 that defeats the intent of the tariff. And that is contrary to case law. That includes the National Van Lines case, as well as the Pennsylvania Central case that are cited in our briefs. The intent of Section 3G5, just like the intent of the 2004 initial decision, was to have the quality bank administrator monitor the common stream, right, through testing, and then only update the values that are used to value resid if he determined in his discretion that there had been a significant change. Under Mr. Ediger's interpretation, apparently, right, we can do nothing, right? But if the quality bank administrator had actually done that, then that would violate the intent and the spirit of Section 3G5, if not the specific letter of the tariff itself. And I will just note that if a tariff is subject to different constructions, that which is reasonable and consistent with the purpose of the tariff is preferred to the one that is impractical or leads to absurd consequences. Thank you, Your Honor.
Thank you. And I believe now the case is submitted.
This honorable the February 11th at 9:30 a.m.